Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions in the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. On this show, I interview lawyers ditching the billable hour and experts who can help attorneys move beyond billing time. Thanks to my sponsors, 650 and Gavel. Links to both in the show notes. More on them later. And use the code LAWSUBSCRIBED when signing up. You get 10% off, and it supports the show. The best way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. I'm thrilled to have with me today on the podcast Jonathan Steele. Jonathan, welcome to the show.
Thanks, Matt. It's good to be with you.
Well, I'm glad you reached out. For those of you who are longtime listeners, I don't even know if I've said this before, but I'm on a number of podcasting platforms out there, and Jonathan was kind enough to reach out through one of them because he's got a lot of good stuff to share with you, and I'm happy that he did. But later we discovered that I know some of the partners at his firm. But other than that, I'm going to learn a lot about what Jonathan has to share with us today. So for me and my listeners, Jonathan, go ahead and give yourself a little introduction.
Sure. I'm a divorce lawyer by day. So I work at Beermann. We do divorce, we do paternity, prenups, postnups, anything you'd want to avoid in your personal life, we do that. And that's a typical structure of a billable hour practice. We take retainers and we bill against them. And then I've recently gotten into cybersecurity and privacy consulting, where I somewhat wear my lawyer hat, and that is a subscription model.
So why even get into this cybersecurity and privacy thing?
You know, that I've been asked that question a few times lately, and it's, to some extent, I've always been interested. You know, I've been on like the Signal platform and using Proton Mail as long as they've been out, so like 2014 or 2016. But it's a recent infatuation. It's, you know, probably a COVID rabbit hole I went down when everybody else was learning about Tiger King and how to bake bread. This was the rabbit hole I went down. I was watching YouTubes about it, reading about it, taking certification courses about it. So it just became a fixation or a hobby.
I think I've only had one cybersecurity privacy lawyer on the podcast before, and she left the practice of law, Donata Strength Skillroot, to launch Termageddon, a productized legal offering, so not legal services, for terms of service privacy policy. Have you come across Termageddon or her work before?
No, but it sounds interesting to me. I've not heard of that.
Yeah. So I'll have to share that episode with you after this, and this will probably make a good companion episode. So everybody go back and listen to that one. So I was in the pandemic figuring out how to launch my own practice. So I went down my own separate rabbit holes, and frankly discovering that there was a massive lack of information around how do you start a law firm that's like in a modern age and like that's useful. And there was like one ABA article on subscription legal services. So that's why I started the podcast. Something I talk about a lot when I give CLEs on the subscription model for legal services is around all the technology. And I like barely touch on the cybersecurity aspect of communications with clients. Basically, it starts and stops at use a client portal with two-factor authentication login. And you should not be emailing or texting documents that are not, it's not via an encrypted means with your clients, because it's probably malpractice. And that has nothing to do with being a subscription, legal services providing attorney, but it's just good practice. And you're going to have these technology tools to be more efficient anyway. So maybe, let's get your input on that and all your opinions, not a cybersecurity advice, right? Just for educational purposes only, but let's get your opinion on that. And maybe if you could explain in more detail why that's important.
Yeah. As recently as of an hour ago, I had a debate in my office about using ephemeral messaging with clients and whether that's a good idea, a bad idea. And for listeners that don't even know what that means, it's a self-deleting message. Like Signal has the ability to delete your messages after 12 hours or one day or whatever interval you like. And there's two sides of the coin. On one hand, every so often, lawyers will get a subpoena saying, give me all your messages with your client. And if it's your custom and practice, categorically to have an auto delete timer, I don't think there's anything wrong with it. And yeah, they're privileged normally, but sometimes that privilege gets muddied if there's other people on your messages. Mm-hmm. So it keeps it clean. And, to your point about sending documents and things like that over email, that's a pet peeve of mine. Clients do it all the time. They attach their tax returns with their social security numbers as email attachments. And I Mirandize everybody, use a secure upload link so that it's not sitting in somebody's emails. And I'm getting through to people, but very, very slowly.
Right, right. I mean, how do you feel then about even having attorney-client privileged communications over unencrypted email or text?
I think it's negligent. I try to get all of my clients on Signal. I try to have all my communications on Signal. We have a pretty high duty of maintaining privilege with clients, and I think even like plain ordinary phone calls, somewhere along the line, somebody could be listening. Text messages are horrible. Plain old SMS messaging is horrible. And I don't think you're doing your job as a lawyer if you're not using the most secure method of communicating with your client.
Right, which is why I fall back on client portal login two-factor authentication. It's still not going to be perfect, and it's not like truly encrypted communications, but it's better than email. It's better than text and phone calls. No, you raised a great point. I don't think I've said it in a while, but I think I said in my original CLE I did is I prefer clients to do an encrypted Zoom meeting, even if we keep cameras off. Yes, sure, encryption can be cracked, but I feel like an encrypted Zoom meeting with my client, assuming they're in a private space, is going to be better, is going to be more secure from a cybersecurity standpoint than a phone call. Am I right to just lacking the sophistication? Is that like a better approach?
It The short answer is yes, but it's a little bit more nuanced than that. Zoom got called out pretty early on in the pandemic for playing around with what does end-to-end encryption mean. And as part of a lawsuit, they had to roll out true end-to-end encryption. So it's as simple as a toggle in your Zoom settings, but there's one version of encryption where Zoom holds the keys, and then there's another version where it's end-to-end and you hold the keys. So if you have turned on end-to-end encryption, 100%, it's more secure than any form of phone call. If you're letting them hold the keys, well, then it's a question of do you trust Zoom? I personally don't. So
I trust Zoom more than I trust me personally, actually. Like Zoom is is a multi-billion dollar? Yeah, I think it's a multi-billion dollar company, and they have far more resources to put towards maintaining their encryption levels than I do personally. And I'm looking at this now, so I have, which is looking at my Zoom settings for this call, which is my default. I have enhanced encryption turned on, whatever the heck that means. I definitely turned on encryption, and I think about this stuff. And I'm still not sophisticated when it comes down to it. Like, I didn't understand before you explained it to me. I didn't understand that Zoom holds the keys versus me holding the keys, right? At a high level, I get what that means. But think about our profession on the whole, right? Like, the reason I don't think we're seeing attorneys get in trouble for this is because every single attorney, other than maybe you and me and a couple of others I know, would get in trouble with this, and it'd open the floodgates, right? And like, no lawyer is going to want to be like, no lawyer sitting on the board that disciplines attorneys is going to want to discipline an attorney because they've emailed with clients over email, right? So they're guilty of it too. So like, I think the message is important for what you're talking about. I think it's highly unlikely though that like any lawyers actually ever get in trouble over this thing.
I think as the younger generation makes their way into the Attorney Registration Disciplinary Commission, then it'll start to change a little bit, but it's the older generation that they don't know any better. And,
Yeah.
like some of the older partners here at the office, I will call them on FaceTime audio rather than a regular phone call. And to this day, they don't understand why or what that is or where the video is when I'm calling, and I have to explain it over and over and over again. So it's a learning curve.
Oh, that's fascinating. I'm picking up tips here for if my does the receiving call have FaceTime or have to be an iPhone?
I think you can FaceTime with non-iPhone users, but I don't know 100% whether that's full end-to-end encryption, whereas it is if you're iPhone to iPhone.
Okay, interesting. Yeah, I had a client whose phone was malfunctioning for a while, and that was the only way they called anybody. And little did they know it was more encrypted communications.
The distinction I guess I would try to clarify for you between enhanced, like Zoom uses, or end-to-end is if you look at an apartment rental where the owner of your unit has a key, they have a spare key to your unit, and so they can come in if they choose to. When you use Zoom's enhanced encryption, they have a key. And so at the end of the day, they could decrypt your data. If it's end to end, it's you are the owner. You have the only key. With iPhones and FaceTime, that is end to end. So that is better.
Yeah, I know Apple cares a lot about security, and there's a, especially with Apple Intelligence and everything going on with their integration with OpenAI and whether or not you're really knowingly giving permission to send things back and forth with OpenAI is a whole hullabaloo. So that we're not going to go into that. This is not the podcast to go into the nuance of that. Last question I have about you on this, because it's so interesting to me. And then we'll get into more back into the subscription and what you're doing with that business model. Is in as a litigator in a potential case, have you ever thought about maybe trying and seeing if a judge could be convinced that that the other side has waived privilege, and to get access to what was formerly privileged communications?
I've been on the defending side of that more times than I would like to. Whether it's a client, they chose to copy their friends or their family on a message to me, and then it's, you've destroyed the privilege, or they forwarded a text that I sent to them, and so they say that they've given up their privilege. So I've had to defend that about half a dozen times in the last 10, 12 years, and it's worrisome every time.
Yeah, I mean, but even without copying a family member, if you're just unencrypted emailing back and forth, like, I think, as a non-subject matter expert, that's waiving privilege.
That's an argument. I don't know that that would work. Judges like to give you the benefit of the doubt. They like to keep that privilege sacrosanct if they can.
Yeah.
I think they feel stretched when they hear you're not the only person on the email thread, because then they know that the privilege has been destroyed. But I think if it's so technical as it wasn't end-to-end encrypted, that's going to be hard to find a judge that really understands that nuance.
I think that's the only, like, a case like that gets appealed
Yeah,
is the only way our profession is going to start to use end-to-end encrypted communications.
you're probably right.
So we're looking for a judge. If there was some ACLU equivalent out there that wants to actually help attorneys preserve attorney-client privilege, go find that case and do some forum shopping, which I know is controversial. So moving into the business model that you chose. So you mentioned that the family law practice that you're at bills by the hour. Yet you decided when you started this other company that you were going to use subscription. Why?
I think subscription model is preferable to me for a number of reasons. One, I think having a bill by the hour, it drains the life out of you. Being a slave to that requirement every month of having to hit your billables, it's problematic for so many reasons. It encourages, I think, people to pad their billing, which is unethical and a disservice to clients, and gives us as lawyers a bad name, and encourages all these jokes that you hear about lawyers and being sharks and bloodsuckers and all of that. I think moving to a subscription, it allows me to do the full depth of what I think is necessary to help protect the client, both from a privacy and a security perspective, without being constrained by the client's resources. So if I were billing hourly, I'm going to outspend most of my clients' ability or willingness to pay for these kinds of services in an hour. But if I price it in a subscription way, I'm not constrained by you need to bill within a reasonable amount of time and curtail your services to that time.
Or the other side of that, are you finding that you're able to create standard operating procedures, duplicative processes, automations that help you service the cybersecurity clients?
Automation for sure. You touched on it earlier, and I'll stay with you to not go down the rabbit hole of AI and all of that, but automation's huge right now, and AI is helping to automate. But for sure, integrating automation into some of the vulnerability testing and penetration testing, and trying to see where a client has exposure and what their digital footprint looks like, would be way time prohibitive if it weren't for automation.
Are there any particular tools? Because we still, even if we're not going down the rabbit hole, we still like to talk tools. So, like, what tools are you using from a technological standpoint that are helping you deliver this subscription model service?
So I don't know how technical you want to get, but I run various scripts on my computer all the time. I have little mini computers that are called Raspberry Pis that are low power. They're about $150 yay big computers. And I leave them on. They run all day long in various different places. I have a few in my home, a few in the office, and they run scripts. And they're called Python scripts, and they automate certain things that for me to sit there and do manually would be wildly time consuming, whether that's, interacting with social media or generating images or doing, like, for instance, to this specific content of penetration testing, one of the services that we offer and try to help people with is seeing what personally identifiable information is out there about them as it is. If you Google someone's name, you can normally find their address and their phone number and their relatives' names and all sorts of alarming information. And it's a game of whack-a-mole. You can remove that information, but then it pops up on another data broker. So having a script be able to run automated 24 hours a day, scanning for any personally identifiable information is a huge time saver, and it's scalable. So if I have 1,000 clients that all need that to be going on all the time, it's no sweat off my back, and it's really no sweat off of $150 computer's back. It's just a script that's automated. So it's a pretty efficient way of doing something like that.
Mm-hmm. Have you seen that with the advent of Gen AI in particular, that you've been able to add that into the scripting so that what you're capable of doing has increased?
Yes, and for two reasons. One, it is able to audit the code of your script, find errors, find improvements in seconds, whereas coding that manually takes hours. Finding vulnerabilities, finding errors in logic, or even just something as simple as like a syntax error. You put a parentheses one space too far. That would take you hours to find that, but you copy and paste that to ChatGPT and it'll find it for you in seconds. And then within your scripts, you can integrate what's called API access that allows you to integrate directly with ChatGPT or another form of AI. And you can have it analyze log files for you. You can have it analyze PDFs. One recent integration that I'm using that relates to my law practice is I have a script set up that every morning at 9 a.m. it downloads all of the recent case law that has been released for the day. It scans the PDF, it summarizes the cases, and it emails me every morning. Here's the cases that have been released. Here's a summary of the cases, and here's the case attached. Doing that manually would be hours and hours every single day. So automating that was huge.
Here's a subscription business for you. Sell that to lawyers for a monthly fee.
I think that, there are so many business opportunities that capitalize on this automation. The possibilities are endless. Every time I do something like this, somebody says to me, that is a business in and of itself. And they're right.
Yeah. Yeah. I mean, right now it's giving you an advantage probably in being aware of the case law ahead of time. But just like with all things with technology, over time, the advantage will be less advantageous as more and more people, as you're doing that for yourself. There are legal tech founders listening to this podcast. They might go with that idea and run with it, right? Because they're not practicing law full time. They're either recovering attorneys or they were never an attorney. But I mean, that right there, like there's value. And I don't know what a lawyer would be willing to pay for that. $50 a month, $100 a month, like something maybe. And, they'd have to, I get that you'd have to build an app and some kind of like probably fancier interface, like a front end, piece of it. They have to pick what practice areas. Like I could see how it could get out of control pretty quickly as its own business model. But to those of you listening, I mean, there might be something there. Everything that you just said, in my opinion, on the coding side of things, seems super complicated, right? By the way, are you self-taught or did you learn formally how to code and all that?
I would say self-taught, and I'm helped by AI in how to learn. Yeah.
Right, right. But everything you said about how you're leveraging Gen AI for code and blogs can be used for substantive legal work, right? Have you thought about plugging in a motion that you're gonna file in court anyway? I mean, or you could use legal AI tools that you're paying for, so that that's not training underlying models, and asking it to run a diagnostic test on, are there any logical errors in these arguments, right? Summarize this for me so you could put a nice little summary paragraph without having to draft it, right? But I mean, but that all cuts against what is definitely billable time, right?
That part of it worries me. I'm reading and I'm hearing all these stories where a lawyer just basically dumps their drafting onto AI. AI spits out something sounding good. It sounds authoritative. It's convincing. It cites case law. And then they come to find none of those cases exist. And it's the AI completely making it up, and they get sanctioned for it. So I think, it concerns me a little bit. I'm not confident in the current iteration of ChatGPT to offload my drafting. But I think there are certain things, you can certainly use it to clean up your language, to fluff up, to clean up the grammar, to clean up the spelling, to help with formatting, things like that. I think I have a little bit of some privacy concerns with OpenAI, but if you put those aside for a moment, you could upload 5,000 pages of transcripts in a PDF and say, give me a summary, and it'll spit out a summary in a minute. Whereas it would take you the better part of a day or two to get through all of those transcripts, to find any inconsistencies, to find areas for cross-examination. So there are ways, I think, of using it that I don't have as many concerns. But on the drafting front, I'm not there yet. I don't think it's there yet.
Well, and to be fair, and longtime listeners know, because I've had a lot of Gen AI experts on the pod, using ChatGPT to write a legal anything that needs case citations is like using a mouse to hammer a nail. It's not even close to the right tool. It's not connected to case law. It's not leveraging retrieval augmented generation, right? Like these legal AI tools and what Lexis Plus AI and Case Text Code Counsel and Paxton and LawDroid do, for example, is they're plugged into case law. So like those would be the tools to actually do like newer versions of legal research with Gen AI. But I was just talking about like you did the research, like you did everything traditionally to draft the thing, and you're going to file it publicly anyway. So it's going to be a matter of public record. I mean, unless it's under seal, and all that. But if it's going to be a matter of public record, I see very little harm in even using the free tools. Now, I still wouldn't recommend it because I think just like with people, if you have legal training and experience, it's going to make you do a better job at having a cybersecurity and privacy business, being a politician, being a CEO, right? It's going to make you better at anything. I use the paid legal AI tools that my firm uses that are SOC 2 compliant, et cetera, to do things I would use ChatGPT for, right? So I'd still suggest to the listeners that they use legal specific tools even for non-legal things. But even if you're not willing to pay the $100 a month or up that these tools will charge you, I still feel like free version ChatGPT for something you're going to file anyway, the legal research was done traditionally, you could end up with a much better filing, a much better brief, motion, whatever, by leveraging AI in the same way that you talked about, previously.
So I would only say it's not you will end up with a much better filing. My privacy concerns aren't so much around the drafting part, because I agree with you. It's going to be public record. Who cares? But where I see some issue is, you want to upload a client's bank statements to ChatGPT and say, give me an analysis of bank statements. Well, then I'm a little worried about, is it private? Is it secure to upload my client's bank statements to OpenAI? I would have some concerns about. But I agree with you that it will make your presentation better. It will make your delivery better for sure. And I think that the lawyers that are resistant to this trend are the ones that are going to get left behind. It's here. It's not going anywhere. So either you learn and you adapt and you use it to your advantage, or you're going to get left behind.
Yeah. And at least with Paxton, which is the tool that I'm using, they've developed their own legal large language model. And I think they do plug and play in certain instances, like with like multiple layers in between them and some of the other models where they otherwise would train. And, they have the enterprise contracts, which at least claims that they're not training the underlying models for that. And a lot of these legal AI tools have these that are GPT wrappers. They'll have like the enterprise level where it says it's not training or whatever, right? So to a certain extent, like I'm hesitant to believe that OpenAI is not just doing nefarious things, but for their own large language model, and they're a tool designed for law firms where they build it for security purposes first. I mean, I do get my client. I let my clients know when I'm throwing something through an AI tool. I'm leveraging it for analyzing PDFs, contracts, other things. There's no personally identifying information. Like I'm not working those kind of cases, right? So like no social security numbers, no medical records or nothing like that, right? No, and frankly, no bank records either. So like I'm not uploading that stuff because I'm not working on matters that involve that kind of thing. But I'm absolutely summarizing a 660-page franchise disclosure document using Gen AI. And it is a massive time saver as an attorney who's not billing by the hour. And e-discovery's been around for a long time, and it's only gotten better with Gen AI. I mean, I don't know, like, I've never practiced family law. Like, is the volume of documents, does that ever even require e-discovery software? Or how are you analyzing those docs?
There are some cases where we will outsource that if it's a large, complex case. It's rare from what I've seen, but it does happen.
Yeah. So,
And to the earlier point you're making about telling a client you're using AI, I think whether you're hourly or subscription, I think that it would be hard. You'd be hard pressed to find a client that would object. I think the clients are going to be all for it because your work product is better, it's more efficient, it's faster. So why would they not want you to deliver a better product faster?
right. And if I handled highly, highly sensitive information, even though I'm using AI every day in my practice, I would be much more hesitant to throw it into even these legal AI tools, right? I'm just not dealing with that highly sensitive type information. Now I have a question for you that I didn't prep you for. Not that I do much prep on the show. For former guests of the show who still listen, I don't like do a lot of prep. But after learning about the Raspberry Pi scripts that you're running and looking at this message that you sent me through the platform, was that run by one of your scripts? I'm curious.
No,
Okay. Okay.
no, I,
So,
I don't. I don't use. There are certain things that I don't use GPT for. I don't use it to write like client emails. I don't use it to write emails to other lawyers. Or I like my own voice. I have a certain writing style, and I sort of worry that if I just offload my writing too much, that I'm going to lose it. That I'm
yeah.
going to lose my wit. I'm going to lose my snark, and I like that. That's one of the things I like about being a lawyer. So no, if I'm writing to someone, it's my voice.
Okay. All right. That's interesting. I'll still use AI to augment my writing, but it's very well structured. I must say that I mean, you are a practicing attorney litigator, so your writing is just very structured in general. But if you told me it was AI, I'd have believed you though. So, and,
You
and
know,
not,
there
and not judged you for it in the slightest, by the way.
there are a number of tools out there that purport to be able to analyze writing and tell you if it was written by AI. So feel free to fact check if you come across one of those and plug it in. I don't
Oh,
think they're all accurate all the time, but you know, that's why I use the word purportedly. That there
right,
are
right.
some where they'll claim to say, with 99% accuracy, we can tell you that this was or was not written by AI, and we'll see. I think that's going to be a useful tool for teachers where the students are using AI to write their papers.
I feel like I trust those less than I trust OpenAI to keep my data secure. In my
Probably.
opinion. Right? And like I don't know, like I'm in the process of making my first hire, and I'm looking for a law student who has Gen AI experience. Like I'm specifically looking for that. So like I want students to use these tools because it will help me deliver better work product faster to my clients, right? So like use it. Teachers should not be using that software to identify Gen AI. If I'd be using it if I were a teacher, Jonathan. I'd use it to see did they use AI, and if they didn't, I would say why aren't you using AI to make your writing better?
And then use it to grade their papers. Again, I think either you're going to learn how to use it or you're going to get left behind. I think it's an asset. I think it should be on your resume that you know how to write prompts for GPT, because the people that say, "Oh, I've used it and it's not that great," those people are using it as Google. They're saying, "What's the weather in Chicago?" And that's not even scratching the surface of the capabilities that it has. So if you're not getting good results, it's because you're not writing a good prompt.
Right, right. I mean, You're at a billable hour firm, Jonathan. Clearly see the writing on the wall. What are you doing to try to? I mean, you've obviously got the subscription business for what you're doing with cybersecurity, but what are you trying to do for the practice? Because you could see it, you could see it coming, and billable hour is not long for this world. I think I'm inclined to say that you probably agree with me after this conversation.
I do. It's a hard thing to break out of if you're in the mold of a billable hour firm. It's a hard thing to do to convince everybody in one fell swoop that let's do something entirely different. The law seems very resistant to change, and just trying to convince an industry as a whole that this is the wrong way to do it, you're going to get met with, well, this is the way we've always done it.
Mm-hmm.
And I hear that authority cited in courtrooms as though that were authority. Counsel, we do this all the time. Yeah. Does that make it right? No. The fact that we've been doing billable hours for decades, does that make it the right way to do it? I don't think it does.
Mm-hmm. What about the fact that attorneys like me who focus on problem avoidance, upstream legal problems before they actually blow up, I do a lot of prenups, all flat fee. I usually have them subscribe unless I get them through like a lead platform like Hello Prenup, who provides prenups as a product. They have like a panel of lawyers that they vetted, and I'm one of those lawyers to recommend to their users as a way to still beef up and make sure it's an enforceable agreement. Because as I'm sure you know, in Illinois, each side needs an attorney if you want that thing to be more likely to be enforced, right? Just legal information for any potential client listening. And so I'm doing tons of these. And so as more people are getting prenups, the length of time for divorce litigation will decrease, assuming the prenups are enforceable, right? And we're doing everything we can to make sure they are. We're ethically obligated to. So then it gets to a point of, well, if they're not taking as long, but there's still value being provided by family law attorneys if there is a divorce with an existing prenup, like you got to flat fee that stuff, right? Like that's the future of it as there are more and more couples getting divorced who have a existing prenup. Like, are you seeing divorces with prenups in place?
We see a lot of divorces with prenups, and one of the main selling points of a prenup is, in theory anyway, it streamlines a divorce. It spells things out in advance, so there's less to fight about. But then you've got the people that are, unfortunately, slave to a billable hour. Sometimes one of the downsides is it encourages people to take positions that aren't well grounded, because they're just running the meter to advance a claim, whether it's meritorious or not. And so you get a lot of frivolous prenup challenges, and then you end up litigating the prenup, and it doesn't end up streamlining the case. But in theory, that's what it should do. There's obviously parts of a divorce case that you can't even touch on in a prenup, like child custody, which isn't really custody anymore, but or child support, or things related to the child, you're going to have to either fight out or settle with or without a prenup. But it should, in theory, reduce the fighting, reduce the legal fees, get you closer to a flat fee. Although I've seen so much resistance or reluctance to take any cases in family law on a flat fee.
I've only seen one lawyer, and she's been on the podcast in Illinois doing it. And I know of at least a couple more in Colorado who are doing it. Now, in Colorado, they've got a more structured like format for divorce cases where it's like you have like certain stages and you must attempt like some sort of alternative dispute resolution. Like they mandate it, right? So like they flat fee like up to like that point, and then there's like a slightly different but still try to be predictable fee structure if you have to take the case to trial. And then this other attorney who's doing it in Illinois, I think she's doing a combination of subscription and flat fee to provide family law services for couples getting divorced. So I know it can be done because it's being done. It's just a question of the will, like you said.
Well, it's also a question of where do you set the flat fee, where you don't end up way behind at the end of the case. And, over the years, I've done various family law things on a flat fee, like defending an order of protection, or, as you mentioned, doing some prenups. But then you end up behind a lot. If you're defending an order of protection that you thought was going to be a 1 or 2 hour hearing, and it ends up being a 3-day trial with an appeal at the end of it, you probably didn't price your flat fee correctly.
Yeah, that's a pricing question, right? And that's a scope of services thing that can be sorted out in an engagement agreement, right? So I still think you can account for things like that. And one of the values of the subscription model is the longer something takes, if it goes an extra month than you thought it was going to go, you are still making money. And being behind on something assumes you're tracking your time. And when you're tracking your time on subscription and a flat fee, the less time something took, the more money you make, right? And so you build like what you're doing with Raspberry Pis. I mean, like I'm thinking, I wish I would have known how to do all that. I could probably, instead of hiring a legal extern, I could run a bunch of scripts instead that do a lot of the things that I wanted to do. Maybe I have to hire somebody who could just help me build some Raspberry Pi script running software, so or programs, so that I could just automate all these things that I'm doing already.
That's a big maybe. And that's the fear for a lot of industry right now, is that AI is going to replace us. I don't think it's going to replace lawyers anytime soon, but it'll help streamline definitely parts of your practice, make certain things more efficient. If you have the time every morning at 9 a.m. to read 6 cases and distill them down to the key points, uh, God bless you. But that's hard to find the time every single day to do that. So scripting, it's key.
Yeah. I have another question about family law and subscription, because I just hypothesized this during my CLEs with subscriptions for traditionally seen as very difficult to disrupt billable hour type industries such as family law. And it is post MSA or divorce decree compliance. Wouldn't there be a really nice sort of maintenance ongoing subscription plan that a client could have with a law firm where there's this dispute comes up, this things. I mean, you could have your subscriber benefits, right? You could well define subscriber benefits for post MSA or divorce decree compliance, because stuff happens. And like clients don't call you, and stuff happens, and it gets worse because clients don't call you because they're afraid they're going to start getting billed again. So isn't there like a revenue opportunity for family law attorneys and firms to offer like a subscription plan post divorce? And I know if you're billing by the hour, they're probably like, I don't want to pay my lawyer any more money. So I think that there might be a little bit of a problem there. But even if they're thinking, even if I bill subscription and or flat fee for litigation, in any litigation, but particular family law, because that's your experience, that the revenue doesn't have to stop at the end of the case, because you could continue to provide valuable services for post case, post trial or settlement compliance afterwards. And so what do you think about that kind of opportunity? I've got to imagine you've helped lots of clients at the end, quote unquote, end of a case, with issues that arise later on.
I think there's definitely potential there. I think it's not just limited to compliance. I think there's modification proceedings that happen all the time. If there's something child related, there's no such thing as final. Everything child related is temporary in theory. Like, you can have a permanent child support number, but it's always subject to modification. All parenting time is subject to modification. Decision making, assuming you're past a 2-year sort of like cooling off period, is subject to modification. So your post judgment subscription model could be enforcement, it could be modification.
It could be tiered. Do you just want, enforcement related help? It's tier 1. You want enforcement and modification? It's tier 2, right? Or like you have, a different structure of subscription add-ons. Like my business model has subscription add-ons. Somebody's acquiring a business that's an asset purchase agreement add-on, and upon closing, that add-on comes off, right? But they're still subscribed at the other level, so I could help them post closing of that transaction with other matters and questions as they arise, right? So yeah, I think there's a pretty significant revenue opportunity for law firms, and frankly, for the clients. Like when I say revenue opportunities for law firms, the clients get pricing certainty, and they get legal help that they need. So just because law firms could potentially be earning more revenue by leveraging the subscription model doesn't mean that's bad for the clients, because if you're able to do that at scale and for all your clients, you could still offer like predictable, reasonable prices, right? Because it's all, like you mentioned with the cybersecurity thing, it's about scale. With the Raspberry Pis, it's about scale. And the subscription model just scales because billable hours are capped at how many hours can you bill in a day.
You're absolutely right. I don't think it's hard to imagine that it's a direct benefit to a client. I would be hard pressed to come up with an argument that it's in any way detrimental to a client to offer post decree at a minimum in a fee structure where it's subscription based. I don't know that I could give you a colorable argument about how that's detrimental to a client.
Even if it's, $100 a month, and you could schedule 15-minute calls with us. Schedule, not call us whenever you want. Schedule, and 30% reduced billable hour rate for anything that other than that we can't handle in a phone call. Even that's valuable. And they might never have an issue. And now the firm is getting $100 a month for the client getting access to scheduled calls and access to a discounted billable rate. Now, I'm generally not in favor of doing anything billable and subscription combined, but anything for baby steps, man. Anything to get some billable hour-minded attorneys in the mindset of, let's give this subscription thing a try. And once they get a taste of that recurring revenue, they're going to want to turn everything into recurring revenue.
You're not wrong. It's definitely an enticing proposition. I think some of the barrier to entry there is going to be like clients that take advantage of your subscription in that first month and then drop the subscription. But you can bake that into the subscription agreement. You can have a year-long subscription, or
yep, yeah, you're coming up with solutions to that problem right now on the fly. Like, lawyers are some of the smartest people I know, and I'm only slightly patting myself on the back when I say that. If we didn't have a choice to ditch the billable hour, we would come up with some really creative business models. It's just there as an option, which is why I always encourage at the end of a CLE, engage in the thought experiment of your, whatever licensing body that you're governed by says the billable hour is going to be banned in 365 days. What are you going to do? How are you going to plan to prepare, right? And give yourself the next year to figure it out. So with that, I mean, we're time has flown. Just high level, like, how are you pricing your subscription for the business that you have?
Yeah, so I have 4 different tiers, depending on how thorough of advice you want, how thorough of protection you want. And it's based on the level of service and the number of services. On the high end, which is obviously where I would recommend people be, it's $200 a month for what's called the Fortress plan. And then on the low end, it's the Guard plan, and I think that's at $129 a month. But there's a promo code for the first year where it gets you 50% off. So
yeah, and you could do things like that, right? Which is hard to do on the bill. You can't, what are you going to do for the billable hour? And once people are subscribed, like the churn rates of after someone's been subscribed to something for 3 months significantly reduce. So it's easy to give them a discount for the first, however many months or a year. Because if they're seeing the value from it and they continue to get value, they're going to subscribe. They're going to stay subscribed, right? And the way that I handle that is I just charge as low of pricing as I possibly can at the lowest subscription level, starting at $20 a month and $50 a page, right? And once they start to appreciate the value, I just move them up a tier. Because in legal, it is hard to give a discount code for your subscription, right? That's hard. I haven't solved that problem yet. The way I've solved it is just super low entry level subscription, right? With limited subscriber benefits, right? Limited. That's the key. Well, I love it. And I'm glad that you're calling the subscription level something, because that's always another question that I get is how do I name my subscription? Did Gen AI help you come up with that? Or that seems like you maybe came up with that.
That was me that came up with it.
So the last question I like to ask all my guests is just a fun one, Jonathan. And that is a hot dog a sandwich, and why?
That's certainly one you didn't prep me for. Is it a sandwich? I think so. It's got 2 pieces of bread in theory, unless you don't consider the top and the bottom to be separate pieces. And then there's some contents in the middle. So okay. I think so.
All right. If people wanted to find you, or whether it's the firm or social media or the consulting company, what's the best way for them to reach out in all the places?
At first, I'd say good luck. I've done a pretty good job of secreting myself and hiding my personally identifiable information, but my public profiles are the best way to find me or get a hold of me. So there's beermannlaw.com for my law practice, and then there's steelefortress.com for the privacy and security consulting.
All right. For some people, I think that's going to be challenge accepted. But then after they can't find you, they'll realize that they should go to steelefortress.com and get your services, right?
Sure.
So stick around for a minute, but we'll sign off. One more time, Jonathan Steele, thanks again for coming on the show.
Thank you.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn, since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email Kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.